Welcome to Just Verdicts with your host, Brendan Lupetin, a podcast dedicated to the pursuit of just verdicts for just cases. Join us for in-depth interviews and discussions of cutting-edge trial strategies that will give you the keys to conquering the courtroom. Produced and powered by LawPods.
Welcome back to Just Verdicts. Today, I'm joined by Mike Calder and John Perry from Perry Calder to talk about a major verdict they secured in Westmoreland County. Their client, a young man, was left quadriplegic after a pool party incident. This was a case that many lawyers did turn down and would turn down, but these two lawyers saw something different. We'll cover how they built the case, what happened in the courtroom, and the key factors that helped them achieve a life-changing result for their client. Next up on Just Verdicts. All right, John Perry, Mike Calder, the pool verdict. Perry Calder, lots of amazing things have happened over the years. I've been dying to talk to you guys about this case. Thanks so much for joining me on my humble little Just Verdicts podcast, guys.
Happy to be here, Brendan.
And I really appreciate you putting up with all the tech stuff that we had to go through to get here, but it's worth it because people need to hear this story about this case. Michael Fraser versus, we'll just call them the O'Blacks. Amazing verdict, amazing just journey that I've been hearing about for, a decade now, basically. So with that said, guys, thanks so much for being here. And, let's jump into the facts of this case. A lot of people in Western PA have either read about it, heard about the appeal, obviously heard about the insane verdict that came out of this stuff. But for those that aren't familiar with the case, can you give us kind of the basic factual background of what happened that led to this amazing case?
Yeah, sure. No problem. So in July of 2013, Michael Fraser was a 21-year-old in between his junior and senior year of college at Robert Morris. He was studying actuarial sciences. He was an athletic kid, had great grades, came from a great family from the Vandergrift area. He was really just an all-American guy doing things that you'd expect a 21-year-old to do. The date in question was July, I think the 6th. He was at his then best friend, Austin O'Black's parents' house for a 4th of July party. He'd been there a number of times beforehand, so nothing really was out of line. They were actually, the boys, Mike, Austin, and a couple others were hanging out and just kind of chilling before the party started during the afternoon. When they got hot, decided to hop in the swimming pool to cool off. Mike ends up going onto the diving board, leaving the diving board, coming into contact with a large 5-foot diameter circular solid center raft, which propels him forward unexpectedly into the shallow end. He enters the water and everyone in real time thought it was okay. But then Mike floated up, surrounded by a pool of blood, unable to move. One of the boys turned him over so he could breathe, got him to the shallow end. He was rushed by ambulance to a nearby elementary school where a helicopter flew him to Allegheny General Hospital, where he was diagnosed with a cervical spine fracture and treated for that. Mike, unfortunately, was paralyzed from the chest down and remains in that condition today.
So, understanding that terrible story for this young guy, why was there a potential lawsuit arising out of what happened in the circumstances you just described?
Well, that was always the most fascinating question of all, wasn't it? I mean, when this case came to us, the backstory is pretty interesting, in my opinion, because, Mike at the time in the 2014, early 2015 timeframe was really struggling to survive, and life was tough. His parents had exhausted all of their investment in retirement accounts. They liquidated pension funds to convert portions of the family home into handicap/wheelchair accessible space. They were desperate to get him care that he needed. He had just such minimal use of his hands. He couldn't even grip things at the outset of it. So he couldn't even, feed himself, let alone change himself and take care of really regular things that people do every day. So His parents were desperate, and I got a phone call from a mutual friend of Mike's dad asking me basically if I would meet with a man named Bill to hear him out, because as it was, two other experienced and good lawyers had reviewed this case carefully, even sent experts to the O'Black home to investigate, measure, and surveillance the pool. And the case was ultimately declined by those lawyers. And so I agreed, just out of I felt horrible moral decency, to sit and talk with a grieving dad. And when I did, Brendan, we sat at a Panera Bread in Murraysville, and Bill, basically through tears told me that he was doing anything he could to try to find a way to provide some money for his son to get medical care and treatment that he desperately needed, but that wasn't covered by insurance. And the linchpin to it was, he said that the O'Blacks, after Mike's paralysis, had expressed not only remorse, but responsibility for what happened. And as the story went, Mrs. O'Black asked Mrs. Fraser to meet her in a King's parking lot while Mike was at a spinal cord rehabilitation facility. And the purpose of the meeting was for Laura O'Black did this, met with Mary and said, listen, this is all our fault. We knew that damn raft never should have been in the pool because it was too big. It was too strong. We used it to tow behind a speedboat out on Crooked Creek Lake. We've told our insurance company that we want you to be paid. They have told us just to keep our mouths shut and that this will all go away once 2 years and a day from the date of Mike's injury happens. And so we don't know what else to do other than to have you sue us. That became interesting during the life of the trial, but we'll come back to that. So I met with Bill. At the time, I was a much younger lawyer. I got John's permission to go and meet with Bill, hear the story, and ultimately agreed to sign up the case because it was very risky. It did involve a 21-year-old who was at a 4th of July party, and you know the facts. So the idea at Genesis was sign up a power of attorney that specifically says that we will represent Mike to the extent that we will file a lawsuit. We will take the depositions of Mr. and Mrs. O'Black under oath. If they say what we are told they said before, then the case is not defensible and they'll have to tender the policy limits. But if they don't, it will be too difficult to prove otherwise. And so we will abort mission at that point. What ended up happening was we filed a lawsuit within the 2-year statute. I noticed the depositions of Mr. and Mrs. O'Black. They adamantly denied doing anything wrong whatsoever. And from the drive from Greensburg back to Pittsburgh, I literally had the radio off. I stared out the windshield and I gripped my steering wheel with anger because I was utterly repulsed at what had happened. And I was beside myself. And I walked into John's office and at the time he could see that I was visibly upset. And I looked at John and I said, almost myself through tears, I know we made an agreement to abandon this if they didn't come in and admit liability and depositions, but I am so mad. I can't let this happen to this poor kid. We have to take a run at this. What do you think? And, to John's forever credit, he said, Mike, I totally agree. That's awful what they did. Basically, go get them.
John, from your vantage point, what do you remember about that? I mean, you got your stud associate coming up the ranks, but bringing to you kind of a questionable case. From your vantage point, what do you remember about all that shaking out?
Yeah, I mean, Mike's version is accurate. I mean, I was not involved in the daily minutia. I knew Mike had taken some depots and we talked about the case, but when it took a turn, we were the very unpopular people in our office because everybody hated this case because as you know, Brendan, the case law in Pennsylvania is just horrible. I mean, you have 6-year-olds diving into pools who become paralyzed and there's no case there. I mean, the appellate decisions they could not be stronger. And frankly, that was the obstacle of the case that we confronted the whole time. I mean, on its face, this is an adult who dives into a swimming pool and becomes paralyzed. And that's not a case. And so, once Mike put on the gloves and decided we were going to, go fight this thing, he was unpopular in the office. But I mean, I do have a distinct recollection. One day I closed his door and he was, down and out. And, I said, Mike, don't worry about what everyone else here thinks. I'll go try this case with you. And, if we can do good for the Frasers, great. And if not, so what? You'll get some trial experience and, we'll try a case together and we'll move on. Our lives will go on. Mike's may not. So, let's give it the old college try. And so, when we looked at it from that perspective, we found the hook. And, the hook in this case that Mike and I believed in from day one, that no one else ever believed in until the day that the last appeal was over, was that, not only was this a boating raft, but it had a big blue box warning on it. And that warning said, never allow diving on this raft. It didn't say, don't you dive on this raft or don't use this in a swimming pool. It said, never allow diving on this raft. The language was addressed to the purchaser. The language was addressed to the owner. And as you know, the owners covered that up and put, handles on it so that they could pull it behind a boat. And they left that covered up when they put it in their pool. And that was our hook. Mike and I always believed that a jury would understand that, a warning that is addressed to the owner that is then covered up is just blanket negligence. And, that was our theory in the case.
Why did you?
No one ever believed it.
Well, and to the point that nobody ever believed it. I mean, I remember, I think maybe this was before we jumped on, Mike and I and a handful of other attorneys have met, periodically for many, many years now. Actually, talking with you kind of reminds me of how long that group of people has been going on discussing, that we used to affectionately refer to as the reptile group. And I can remember Mike bringing this case up one time, and it was about, hey, look, there's this warning on the tube, and it says this. And I remember most everybody was like, Mike, that case that's a tough sell. I mean, I could see that, John, to use your language, there's a hook there, but by no means a slam dunk. But I'm curious, John or Mike, from your perspectives, why did you think it was significant that it was covered? And I'm assuming it's a cover, but the cover being like more for like being towed behind a boat or something like that, like with the handles on it sort of thing. Like, why did you think that was significant, that warning was covered at the time that Mike jumped on it?
Well, I mean, we were wrong about why we thought that after the case tried, but we didn't know that going in. But our belief was always that if you're going to analyze this case under a premises liability theory, there are the elements of premises liability, one of which says that if the guest can discover the danger himself, then there's no liability on the landowner. And our pitch in this case was that the O'Blacks were in a far better position and had way more knowledge than Mike Fraser had because they read the warning. And we got them to admit that during discovery. They read the warning. They knew that the warning said never allowed diving on the raft, and they did that. By covering that warning, they deprived Mike Fraser of having the same knowledge they had, and they deprived him of appreciating the danger of the raft. Now, the defense response to that was, well, who needs a warning? You don't dive on a raft this size in a swimming pool.
Did you ultimately proceed under a, premises liability property owner, or was it general negligence? It's a good point. I'm sure you guys see you guys laughing. It must have been a pretty contentious issue.
You have to tell the story, John.
Well, we proceeded under both.
Why not?
And, you learn things when you try cases, and we hit the premises liability pretty hard. But when we got to the points for charge, there was a long drawn out argument where the defense was trying to convince Judge Smell that this is not a premises case. Is this an of the land, or, the whole analysis? And really the court and defense counsel went back and forth and back and forth. And the judge just said, I see it as what it is. And, it's got to be a premises liability case. And he looked at us and Mike and I go, well, we don't have anything to add, Your Honor. That's as sound an analysis as we could make. And we understand the law the way you do. And so we tried the case, and it became a great issue in the case because the defense didn't ask for a special verdict slip. It just said, were the blacks negligent? Even though at one point, Mike was arguing that they should be separated out and there should be separate counts. The defense said, no way, you just send it to him generically. Was there negligence against both of them? And we go from there. So once we get the verdict, the defense argument then becomes, can't be premises liability, and there's no general negligence in a premises liability context. And so the issue that came out on appeal that they started arguing was, you can't prove both theories. And we said, well, yeah, you didn't ask for a special verdict slip, so we don't know what this jury found. And even if you're right on premises liability, even if the judge was wrong on submitting premises liability to the jury, we still had a general negligence case. And then they came back and said, no, you didn't. And they quoted Mike's closing ad nauseum, where Mike was hitting the premises liability very, very hard. But there were enough nuggets in Mike's closing, because he's a good lawyer, and in his opening, where we said, oh no, here's the general negligence. And frankly, we had both Mr. and Mrs. O'Black. Their testimony was all about general negligence. So there was enough there to hold it, but the case really morphed. And when it was all said and done, we had another lawyer in the courtroom. And when the alternates were dismissed, as we sometimes do, we sent that lawyer to go talk to the alternates. And it was Trevor Perry who came back and tried to pull a quick one on Mike and I. And he's had this look on his face. We're like, oh man, we lost. And then he gets a big smile. And he goes, oh no. He goes, this case is over. And Mike's like, well, why? And they said, the minute they saw the picture of the raft, case was over. They didn't care about a homeowner. They didn't care about a warning. They didn't care about anything. The picture of the raft, they were sold.
Because it was just a ridiculous looking, massive, like clearly river raft in a pool, right? I'm imagining, I'm not sure if I ever saw the picture, but that was it. That was game over at that point.
So you appreciate the size of the raft. Think about what happened here. Mike Fraser goes off a diving board in a pool that has a deep end, hits this raft, and gets propelled so far and with enough force that he goes through the water and hits his head on the ramp of the shallow end. And that's how he gets paralyzed.
It's like a giant trampoline.
Exactly.
Interesting. That's fascinating. So was there any discussion? Did you talk to any of the other jurors out of curiosity? Was there a thought of, because sometimes I feel like, in the particular region in which we're trying a case, I'm not obviously familiar with what is common, whether it's recreational activities or things that are just so well known in the community. Was there any aspect where like, hey, we've all been on river rafts type thing, we know though, any of that? Or was it just, again, it was just so obvious seeing this raft in that pool that everybody had to know that was, an accident waiting to happen?
Yeah, I mean, we talked to jurors afterwards. They were really enthusiastic and in real time proud of the verdict. The interesting takeaway that we first observed with regard to the jurors was Judge Smale thanked them and then dismissed them. And then I think he had a couple, closing remarks for the parties. When we left, this gives me chills to relive it. The jurors were in a line waiting to hug the Fraser family when they exited the courtroom.
Wow.
One of the female jurors, in fact, hugged Mrs. Fraser and pulled her aside and said, I am so sorry for what has happened to your son and to your family. And I hope that our verdict can give you comfort and can give Mike the treatment he needs. And I hope that you know to call me on my personal phone anytime there's anything that you think I can help you with.
Wow. Amazing.
And we had there was an interesting, well, you know how this happens, Brendan. There's always like pockets of jurors, and there's leaders, and there's some people that are more submissive. So we had a group of 4, John.
Yeah, well, let's just back up, because I don't think either one of us would have remembered this if you hadn't just went where you went, Mike. So we're picking the jury, Brendan, and it was taking longer than it should have. And we had a strike left, and we didn't have any more jurors. So Judge Smell said, well, I have to go back down to the juror room, and I have to get 6 more jurors, and we have to come up and we have to go through the whole thing. And, he's giving us a spiel. And I looked at Mike, and Mike and I whispered each other. And I turned to the judge. I said, Judge, we'll give back our last strike. He looks at us and says, what do you mean? I said, we don't need another strike. We literally debated who to strike. I mean, it wasn't like, we debated who to keep, because we're like, they're all so good. Like, normally you go, okay, that guy's gone, that woman's gone. We're looking at each other and go, okay, how do you pick the worst of the best? That jury was that good, right, Mike?
For sure.
Now, when you say that, was it just the particular makeup of those people, or did you feel that they were peculiarly good for the facts of your case?
Well, so, there is, I think objectively, what can only be described as limited voir dire in Westmoreland County. So we were not given a tremendous opportunity to vet prospective jurors. And in fact, they would come into the deliberation room with us, and they have answered some, pre-populated questions, most of which are like, did you ever get a speeding ticket, So if people didn't answer positively, we weren't permitted to really even ask much of anything. So it happened fast, but I think and John can correct me if he disagrees, but part of what we found to be so positive and encouraging about those jurors was that 60-second overview of what happened to Mike can create an impact on some people that makes them shake their heads. Like, this is a frivolous lawsuit. This is bad. And we did not get that vibe at all from people. We just felt that the folks that came into questioning with us were, at least to our eyes, willing to be neutral, to be fair, and to give us a chance.
So, okay, I understand. So you were permitted some degree of kind of like not the mini opening, but kind of the voir dire statement we do in Allegheny County, where we give a little bit of description about the case, not just this is a premises case, a little bit more than that.
Exactly.
And you were not getting, because sometimes we get, this sounds like a crappy case to me, but you were getting just not super anti-vibes from anybody about what you presented.
Now, in one of the questions that we submitted that the judge did give, and Mike, I think he only gave each side 3 or 4. So you didn't get, Mike's right, it was not great voir dire. But one of the questions that we submitted that he allowed was, do you find it offensive to sue a friend if you were injured on their property at their house? And that was a big theme of the case. The defense just thought, these kids are best friends. He practically lived there. The mother, got on stand and said he was one of my own. They played that to the end. And no juror that was asked the question found anything offensive about suing a friend for an injury that occurred at their house. And some of them even elaborated and gave us positive responses to that. And that was a very helpful question.
Well, it's interesting too. When you say that, because obviously I think the default, and certainly what defense latched onto, was, there's going to be, a character stain on your clients for suing their best friend who could do such a thing. But on the flip side is, well, he was their best friend, and this is what you did to him. You put him in this super dangerous condition, and then you're saying it's not your fault at all. Basically go pound salt. Paralyzed, basically son of ours. So, I could see how that really would bounce the other way with them. But yeah, we've gotten I love where we're jumping around here. But tell me a little bit more, just to kind of, rewind a bit. So, Mike, back to when, you're now at the, to hell with what we said initially, I'm all in on this case. Those depositions, were those you had filed suit and now took Theo Black's depositions with a primary goal to see if, as they had told your clients under oath, they would actually stand up and say, yeah, this was our fault. I mean, that was in litigation. Those were the actual depositions in this case where that all went down.
Exactly.
And did you get the sense that, I mean, just in them, that they had been, for lack of a better term, kind of told to toe the company line? Or do you think that they were now really of the mind of, no, we didn't really do anything at fault?
Let me answer it this way. I believe that Mrs. Fraser was being honest as she recollected the conversation that happened in the King's parking lot. So I can't tell you what caused the shift under oath, but it was a very palpable shift. And I even, I knew that this was going to be a big moment. And obviously, as anyone would, I mean, I took my representation of Mike super seriously. When I deposed Mr. and Mrs. O'Black, it was at the Westmoreland County Bar Association, and this was, probably in late 2015, early 2016, and so it was pre-pandemic, pre-Zoom, everything. But I knew that Mike's presence, A, I wanted him for his own benefit to be able to hear it. B, I thought that having him there in some form may help keep the O'Blacks honest. So I brought an iPad and FaceTimed Mike and had him kind of sitting next to me. So they even had to look at him as they testified as they did. And trust me when I tell you, I mean, there was part of me that was ready for anything when I walked into that deposition, but I honestly thought that at base they would concede some of the big things. So I was pretty shocked. And as I mentioned earlier, I was offended by what happened and how it happened. I mean, they became righteously indignant, and it just amplified at trial. And I know we'll get to this in more detail later, but John, of course, did a masterful job with the O'Blacks. He called them as hostile witnesses in our case. But one of the themes that just resonated with us and really upset us, and I think was powerful to the jury, is John had this great line of questioning with Laura where, we walked through the warning on the raft. We walked through the fact that there was no real rules there. We walked through the fact that this had never happened before. We walked through the fact that Mike's sitting in the back of the courtroom with a service dog and in a wheelchair. And he asked her point blank, knowing all of these things now, would you do anything differently at the next pool party that you have at your house? And she said, no, not at all. She still saw nothing at all wrong or dangerous with putting that raft in that pool. And so when I closed to the jury, one of the things that I said with plenty of argument, fury, well, I told the jury, I said, you've heard it all. I said, probably the scariest takeaway that I have from all of the evidence in this case is that even today, she is still unwilling to admit that it was dangerous to put that raft in that pool, and she'd do it again. And so I said, this is why that when you read question number 1, were Laura and Robert O'Black negligence? You have to make the biggest check mark you can possibly make with an ink pen, because your verdict on negligence is the only way they will ever know that they did anything wrong. And it's the only way that you can ever protect the next person that goes to their swimming pool.
That's awesome.
Yeah, and it really backfired on him, because the other thing that happened during her direct examination was she called Mrs. Fraser a liar. And I'm telling you, there is not a person on earth who would ever look at Mary Fraser, understand what she and her family have done for their son, and think that she had the ability to lie about anything. But once she called her a liar then in her direct testimony, that then allowed us to develop the theory with her. And the reason that you never said that is because you're not sorry. Isn't that the case? And she had to say yes. And you don't have any regrets, do you? I don't. And you're not willing to take any blame for this. No. So, in the classic, you can't have your cake and eat it too. She either had to call Mary a liar and run with it, which came with all those other negative consequences, or she had to own up to it. And by owning up to it, she would be essentially admitting her liability. And in fact, the defense lawyer in the opening, Mike, I think, was like, now, you're going to hear a story that we don't agree with the story, but, even if somebody said they were sorry, that doesn't mean that they're admitting liability. Like, who wouldn't be sorry for a boy getting paralyzed?
That's exactly what he said.
Yeah. When you guys brought this up before, I was really curious about this. So am I correct in understanding that in trial, you confronted her with, isn't it true that you actually had a meeting with Mrs. Fraser and essentially admitted this was your fault and that, that something should be done about it? And she just outright denied that and doubled down.
The only thing she admitted was the meeting and denied all of the contents per Mary's version, and said she just, really wanted to meet with her mother to mother and let her know that they were all empathetic with what Mike was going through.
A lot of good that would have done.
Right.
But that's, amazing though that, you're able to polarize the case. Now she has to pick between, two options and probably, wouldn't you think that if she had simply, she had admitted to it and agreed, yeah, I did feel it. Don't you think in a sense, maybe the verdict would have been a lot smaller? You know what I mean? But when people realize that she just lied through her teeth, she went and told her this person. And then now, you know what I mean? Like that just strikes me as the kind of stuff that's going to really piss a jury off.
I'd like to say yes to that, but I can't say yes because Mike and I could never convey to you how amazing the Fraser family is.
Yeah, right.
I don't care what the defendants did or said. The Fraser family, the family, the brother quit his job and went to rehab with him and took care of him for a year. And then, the brother got married and built a new house and put Mike on the top floor, the beautiful part, the handicap accessible part. And he and his wife lived in an unfinished basement. This family was just, right, Mike? I'm at a loss for words to tell you how wonderful this family was.
Yeah.
The things they did were unthinkable. So Corey, which is Mike's older brother, testified that for as long as they lived together, when they would go to bed at night, Corey set an alarm on his iPhone to go off every 2 hours all night long. And he would wake up, get out of bed, go into Mike's room and turn Mike around in bed so that Mike didn't get pressure ulcers. Mike had obviously dysfunctional bowel and bladder, so he needed catheterized, and he had a bowel prep routine, which involved manual stimulation with devices and the use of suppositories. Corey did that for him multiple times a day, bathed him, showered him, cared for him, but more than anything, did it without ever showing any signs of it being a burden on him. He did it in a fun way to the extent it can be. He never let Mike felt guilty, but not because of anything Corey ever said or did. It was always next man up for him. Corey never had a bad day when it came to caring for Mike. And when Mike was living in Pittsburgh, he, to his credit, after a year of initial rehabilitation, he returned to Robert Morris with the help of family and friends and graduated and obtained his degree. So Mike had a job working in Pittsburgh in the Frick building of all places for a while.
But Mike, don't lose sight of the fact that when he was at school, his mother or his father would drive to college every morning at 4 a.m. and get Mike up and go through his bowel and bladder regimen and get him dressed. And then he would leave for class in his wheelchair and and then another one would return at night and do the nighttime routine every single day.
It took 2 hours. They all testified that it was 2 hours from when they would get Mike out of bed until he was dressed, cleaned, and ready to go out to school for the day. And this went on for, years and years and years. Mary used to wake up at, 4 a.m, go and pick Mike up from Corey's house, drive him downtown, get him into the Frick building for work, then go to her own job, work all day, pick Mike back up, drive him home, make him dinner, get him changed into evening clothes, and leave. And then she would go home and go, they have things of their own to do there. Then at the end of the night, Bill would drive out at 7:00 and go through the evening routine of getting Mike ready for bed and get him to bed every single day. I mean, like John said, there was a lot said in court about how small that family made us feel, even though we try to think we're decent people. It's hard to compare yourself to them, especially in terms of selfless family sacrifice. And that was never going to get lost on a jury.
Right. In their testimony, we had lawyers in the courtroom and young people who weren't even lawyers. One of them was very stoic. And after the day after Mike and Corey testified, we were back in our war room, and they were with us. And one of them had a breakdown, literally. And Mike and I had never seen this person act that way. We're like, "What's going on?" And through tears, this young man said, "I have never seen anything like that. My heart goes out to Mike and his brother and his parents, and I cannot believe." And then he got angry. "I can't believe what these people did to him." Then he said, "But if this had happened to anybody, Mike having the family he has is the only thing that could have any of us be able to sleep at the end of the day."
That's amazing. So why did this case have to try?
Well, let me jump in here because, Mike had really made a connection with this family, and I hadn't. I mean, I was in the office, but I met Mike Fraser when he came to the office for his deposition, but I didn't sit down and talk to him. But, I knew from the time Mike started working with me that he had a good sixth sense. And, he told me how wonderful they were. And so I came into work one day and Mike had this distraught look on his face. And so I went into his office and closed the door. And I said, "What's up?" And virtually almost through his tears, he said, "Mike Fraser has got contractures so bad in his hands that he's not going to be able to keep working. He may not even be able to live his life." And I said, "Is there nothing that can be done?" And Mike said, "Well, there's an experimental thing that they'll do at the Fraser Center in Atlanta."
Shepherd Center.
I'm sorry, the Shepherd Center. Yeah, the Shepherd Center in Atlanta. But his family can't afford it because by this time we were years into this case. They had, as Mike said, tapped every savings account and retirement account they had. Mike said, "We got to do something." And so we kicked it around and we came up with a plan. And our plan was we were going to call the senior people at Erie Insurance and we were going to say, "Okay, you have $1.3 million in coverage. Here's what you're going to do. You're going to save $300,000 off of your policy, and you're going to cut a check to Mike Fraser for $1 million. And we're not going to take a fee and we're not going to reimburse ourselves for our expenses. And you're going to do it within the next week because he needs to get down to the Shepherd Center and get this procedure done. And I'll allow you to take it from there, Mike."
Fell on deaf ears. I never actually even got the dignity of a response. The only response I ever got was, "This case is defensible. This case always was and always will be defensible. And we're going to see it through to verdict." We never got an offer of a penny to settle that case.
That's crazy. I mean, just insane. I have to say, with everything that you guys have talked about, and even with the challenges of the case, that an insurance company would be that. I don't know, just deaf of realizing what this case potentially exposed them to. So now you're going to trial. Can you guys walk us through some of the nuts and bolts? Mike, everybody, I always like to kind of nerd out on structure and strategy and so forth. How did you approach, for example, the opening statement in this case? John alluded to, you kind of touched on a little bit of the general negligence. You talked about the premises. But what was the structure and what was the real kind of focus? Like what were you trying to accomplish, in opening?
Yeah, it's a great question, Brendan. So John and I spent a tremendous amount of time working through different options in terms of theme, because we knew that we needed to capture and package this perfectly in order to sell it correctly to a jury. And so the decision that we made at the outset was that we recognized there was a possibility of a comparative negligence finding by the jury. And so our hedge against a loss from day one was always instructing the jury in very clear, very concise language that their task was going to ultimately be to compare the conduct of Mr. and Mrs. O'Black to the conduct of Michael Fraser. So in opening, I did not talk about numbers. I did not talk about percentages. But when I talked about what we expected their ultimate finding to be, I referenced it in terms of the evidence being clear that the O'Blacks were more negligent than Michael, and that we would talk later in the case about just how much more. But from inception, this was portrayed as a case in which conduct needed compared, and ultimately the adult parent homeowners had more culpability because they had the benefit of a lot more knowledge and a lot more years of life than Mike did. In opening, we also, so an interesting side street to that is there were 4 or 5 eyewitnesses to the actual event that preceded Mike's paralysis. Mike had a closed head injury in addition to cervical spinal cord injury, and so he had no recollection whatsoever of anything that occurred from the second that he walked onto the diving board until he was on the pool deck staring up at a blue sky. The people that testified that saw it all testified to a different recollection of exactly what happened in the moments leading up to Mike leaving that diving board. And so John and I knew that this was going to be an issue. And so there were 2 kind of important / funny / just interesting takeaways. One was, so like one of the witnesses said Mike landed on his belly. One said Mike hit it with his right foot. The other one said he hit it with both feet. The other one said, I'm not even sure he hit it at all. I think he might have just slid off the front. So we always knew that it was going to be a little bit of a free for all in that regard. So our theme from day one was, it does not matter who, if anyone, you believe about exactly what part of Mike's body contacted what part of that raft, because the only fact that matters is that the raft was the common denominator. And if the raft wasn't in the pool, which it shouldn't have been because the warning said so, this never happens. And the O'Blacks were the ones that put it there. And this, Brendan, drove the defendants crazy, more so than anything else from then until the end of the case, because, you know, one of the things that I sometimes do in openings is I always try to pick one thing that I really want to hang my hat on and give it to the jury. And I use the phrase, if you remember anything that I say to you this morning, let it be this. John and I do not know, and we do not care how it is that Mike came into contact with that raft. So when you hear Mr. So-and-so for the defendants tell you about all these different versions and about how that should be resolved against us, you ignore it. We're telling you right now, we don't care, because every version of what occurred involves Mike coming into contact with this raft and being propelled very unexpectedly, much further into that pool than anyone would have imagined. And that was the factual cause of his injury. So that was number one. Number two was our position always was, I mean, not always, but our position from trial was always, you get to the point of a raft being improperly placed in a residential swimming pool and the analysis ends. The O'Blacks put it there. They shouldn't have. They lose. But as to all the stories and all the noise the defense wanted to make at trial, they carry the burden of proof on comparative negligence the same way that John and I carry the burden of proof on their direct negligence. And what can they even prove to you? They have no clue, just like we don't, as to what actually happened. For them to prove that Mike Fraser was negligent, they have to prove what he did. And nobody knows what he did. you're going to hear it from 4 different people. And so how could they ever carry their burden that Mike did something unbecoming of a reasonable guest at a pool party that day? So those were the themes. Those were the major themes going into opening. And it ended up working, I think, masterfully, because the evidence came in, I don't know if I can say better than we expected, but I can definitely say it as efficiently and as great as it possibly could have. And so by coming out of the gate, talking about comparative negligence as a likelihood in the case, but not binding us to any fixed position other than Mike is less negligent than they are, we were really set up for the end of the case to be able to say, oh, it's not even close. And one last thing, John made a comment earlier. I did initially request a verdict slip that had separate questions on negligence, divided one question to Mr. O'Black and one to Mrs. And it just logically made sense to me because they each had different levels of culpability. But B, I was prospectively trying to, again, hedge against the comparative finding because I thought, well, maybe a jury goes back there and thinks they all shared some blame and divides it 1/3, 1/3, 1/3. And I thought that, oftentimes jurors just look for easy outs and easy math, and that would have been a great way to get a larger comparative finding on the defendants than us. But ultimately, the defendants objected to it and requested one question against them both jointly. And of course, for collection purposes, that was a plaintiff's lawyer's dream come true once the jury said yes. But that's how we approach the case, just very generally speaking, from the opening statement.
Yeah, I think, what you just talked about, people should go back and listen to again, because I think the way that you addressed, this comparative fault idea, maintained your credibility without, conceding necessarily that your client did anything wrong at all. I think that's a really cool balance. I haven't heard it, handled just like that. I've heard people talk about, that they're accepting some fault in opening, but that always kind of feels a little problematic to me. But I think the way that, that the jury's job is to assess and compare is a great way to do that. And obviously, I love that, if you remember one thing from this, because I think, you're always going to have that sleepy juror or two, no matter how, magnetic and amazing we think we are in opening. They are going to remember that one. What's that one thing that the guy said? So I always think that's great. And then just the way that you, just approached all of that, to set up the way the trial prepared is really brilliant.
The other thing that tied into that was defense counsel we all make mistakes in trial, but they just went after Mike Fraser, a poor kid in a wheelchair whose life was just tear-jerking. And they had to go after him based on how they thought they were defending the case. And that was dangerous if you had good witnesses. But the thing that Mike and I had developed before we even started the case is we knew the line of questioning that we were going to pursue with Mr. and Mrs. O'Black. And so we had them set up. We called them as on cross, but we had them set up and said, now, Mr. O'Black, as between you and Mr. Fraser, who had more knowledge or who was in a better position or who had more experience? And, we did it with reading the label and covering the warning. And there was a series of, 40 or 50 questions where these arrogant, really bad witnesses, honestly, because they had zero empathy, they had to point the finger at themselves repeatedly. And, that was the other thing on the contributory negligence. And, frankly, we knew that, Vegas wasn't giving us great odds on winning the case. But as Mike already established, our biggest concern was we thought they were negligent. We really did. But we were very, very concerned that the jury was going to come back and say Mike was more at fault because he initiated the dive.
Interesting. And did you talk to anybody to understand, because there was some comparative ultimately, wasn't it? Was it 30%? Was it 60 or 70-30?
Yep.
Did anybody indicate, what their rationale was? Was it exactly what John just said, that, he was the one that jumped in or dove or whatever?
Pretty much. I mean, that, when the jury was polled, they were polled on that question, and two of the jurors were no, and they wanted 0. And we talked to them afterwards, and it was what you would expect, Brendan. There was a compromise on the number, and one of the ways to get to a number everybody agreed to was on the comparative negligence front. But, we had a great legal argument, and we didn't ultimately prevail on that. But the defendants dropped this challenge to what we were saying in the appeal process. But, our point to the judge was, well, first of all, they haven't proven a set of facts, as Mike has already pointed out, like what did happen. And then we followed, Mike's theme. Regardless of what happened, it started and stopped on the raft. And, we had crazy testimony. Yes, we knew they were diving on it. Yes, we knew they were going to play on this raft. Yes, it had been in the pool before. If we had it to do over, we would not have stopped anything. This could have happened to any of the kids. And there was just all this great testimony. So, at the end of their case, we moved to dismiss the comparative negligence. Judge shook his head a little bit, and he's like, you know what? It's all going to the jury.
And I mean, I get your position. It's probably better maybe that it did. I mean, from appeal purposes, that could have been more likely to have a reversible issue if he had taken it out potentially. So,
you're right. And let's follow up on that, because we also made the argument that comparative negligence doesn't apply in a premises liability case. And there's probably good case law for that. By submitting the comparative to the jury, that strengthened there was a general negligence count here, and you didn't request a special verdict slip. And by finding comparative negligence, we know that the jury found actual negligence, not premises liability negligence. So even if you're right on the law about premises liability, we won on basic negligence, and that's confirmed by the fact that there was a comparative negligence finding. In the appellate process, the defendants had no response to that. None. All they could say was, well, the finding of comparative negligence shows that there can't be a premises liability case, because that shows they knew he appreciated the risk.
That's really interesting.
Well, they were obsessed with it. They skipped over the problem of not having asked a specific interrogatory on whether Mike knew or should have known of the dangerousness involving the raft, and arrived without any foundation at the conclusion that the jury's finding of 30% comparative negligence unequivocally established that Mike knew or should have known that it was dangerous. And of course, the general verdicts rule that we've kind of mentioned already bound them with the reality that there was no way to isolate what findings the jury did or didn't make. And you could not untangle that web. And it was a verdict that always had to stand. I mean, that jury heard a ton of evidence, a bunch of theories, and they made a series of findings, all of which were fair and supported by the record. And eventually that's what the appellate courts held as well.
What was your order of, I know, John, you called the Blacks as on cross in your case, right, to establish a lot of that good stuff that you had on them. What was your overall approach to presenting, your witnesses and evidence? Did you start with all the fault? Did you leave with the Blacks? Did you have an expert on liability, like a pool expert or anything like that? Or?
Well, we had an expert. I'm not sure what he was on.
Some of that raft gas.
Oh, it was the most criminal thing I've ever seen. Like he had a report that arguably you could get it was like human factors and, where do they fit in and where can you go? Mike gets this guy on the stand, and I'm going to let him tell you what I said to him when he sat down. But I'm sitting in my chair, like pinching myself. I'm like, is like Mike the only lawyer in the courtroom? I think at one point the judge even was looking around the courtroom. And when you finally sat down, Mike, do you remember what I said to you?
You go, Mike, whenever Judge Smale dismisses us, you better run out of the courtroom because he should send a sheriff after you to arrest you and throw you in jail for what you just got away with.
He went so far beyond the scope of his report, so far beyond what any expert could ever say, so far beyond expert opinion. At one point, he had our expert say on direct exam, well, listen, it doesn't take an expert to know how stupid it is to put a raft like that in your pool and let kids jump on it.
Yeah, he goes, he was a warnings. So on paper, Brendan, he was a warnings expert. John and I always knew that it would be totally inappropriate to try to submit expert testimony on the standard of a homeowner because that's not outside the purview of a reasonable juror, right? How could you have them talk about that? The defendants had a swimming pool expert who all he tried to do was blame, he was a proffered swimming pool expert, was try to blame Mike for doing some crazy aeronautical acrobatic stunt that was in violation of any kind of common sense swimming pool behavior. So we decided to go about it a little differently and called a guy and we proffered him as a warnings expert. And so he wrote a report and began his testimony talking about the considerations that product manufacturers review before they draft warnings and why they draft warnings and is this a good warning and what does this warning mean? And so we got all that, but then as John said, Brendan, you've heard me say this before, but I always feel like whether it's in an opening or a closing or with an important witness, I always feel like if I have not gotten an objection from opposing counsel that I haven't pushed hard enough. So when I started getting some answers from this expert that were on the fringe, I started asking questions that were definitely nowhere near the fringe anymore. I mean, at one point I asked, because he had mentioned that he had 6 children. I said, well, sir, you have 6 children. Would you ever put this raft in a pool with any of your kids? And he goes, oh my God, no reasonable homeowner ever would do that.
Oh, that's great.
Yeah.
Was he your first witness, or where did the things go? Like, who'd you start off with?
Geez, I don't remember, John. I think we started out with the O'Blacks, didn't we?
No, we finished with the O'Blacks. Remember, we had Mary. I know that because we had Mary testify, and then we juxtaposed them because we wanted them to call Mary a liar right after the jury had seen her.
Right.
I think, Mike, we started with Mike Fraser because we were going to have, we knew Corey was going to be fantastic.
Right.
And we knew Mom and Dad were going to be good. So I think we started with Mike because we were concerned about his cross-examination. And we're like, let him beat him up front and we'll clean it up if we have to. So we went Mike, and then our expert Al had to come the next day. So our expert went in there, and then we finished really, really strong. We played a couple of doctor clips, but then we finished really strong with the family.
Okay. Yeah, that's really interesting to lead with your client.
Class.
Yeah. Okay. And that was because, as you said, continue with that polarization, compare their,
right.
kind of BS testimony. They're going to call her a liar right after the jury got to see what a wonderful, incredible person that Mrs. Fraser was. And then, briefly, what was the defense case made up of? So they obviously had a pool expert. Who else did they call?
They ended up not calling him.
Oh, is that right? Okay.
Yeah.
Okay.
It ended up being probably good luck for them not to, because we got a copy of this expert's book that he wrote on pool safety. And there was an entire chapter that talked about dangerous dives and how males are so much more susceptible to misbehavior in pools that you have to be ever so aware of them, and that males well into their 20s are known to be reckless and dangerous, and you have to use extreme caution. I mean, he would have never survived it, but he never should have been allowed to testify because it was just not expert testimony stuff. They called.
Well, I think what happened though, Mike, let's just back up a second, is no one on the defense side, frankly, until they had to sign the check, ever believed that there could be a verdict in this case. And the approach to the case was just that. that you can't get a verdict in this case. So their strategy, I think, was, even though Mike is paralyzed, just tell the facts. And if a jury doesn't get it, the appellate court will clean it up. And so by the time Mike was done with our case in chief, I don't think they knew where they were. And they clearly did not have a strategy anymore. And so when you say what was their case, we took a break and we came back, and Mike hands me a sheet of paper, and I said, "What's this?" And he goes, "Well, these are excerpts from Mike Fraser's deposition that they want to read into their case."
Play.
And Mike's like, "They can't do that." And I go, "They probably can. I don't know why they would." I said, "Did you read them?" And he looks at me and goes, "John, I swear, we'd probably play these clips if we were allowed to." I go, "Well, what are they doing?" And we did not know what they were doing. And so I think they started with that, Mike. They started by playing these clips from Mike Fraser, and then they called a couple witnesses who all said inconsistent things, who, when we cross-examined them, they became our witnesses. And it allowed us to point out things that, we called them kids because they were kids. They called them adults, and they took us to task for calling them kids and said we were trying to embellish and, pull at the strings of the jury. So, when they would call these people, we'd pull their deposition out and say, "Now I'd like you to look at line 15. And we would pull parts of the deposition out where the deponents would call them kids. So, they're trying to blame us for pulling heartstrings. And, and Mike in his closing did a brilliant job. He said, we get blamed for the language we use. Well, we use the vernacular that was spoken in the depots. We're not making this stuff up. And they didn't recall the O'Blacks because they had testified as on cross. They called the son and the daughter.
Right. And they called Samantha, the friend, right?
Yeah, well, the friend, and then they played House of Told, or whatever his name was.
Right.
Adam Reschneider.
Yeah. But so, Brendan, probably the most powerful moment in trial is one that John touched on. I was shocked at the defense's interest in playing these clips because, I did ask John whether they were allowed to do it because I thought, well, the deposition was taken 8 years ago. They just had 2 days ago had a chance to cross-examine Mike on
anything they
stuff.
wanted. Yeah.
Yeah. They could have confronted him with the video clips and they didn't. So why do they get a chance to do it now? Ultimately, I looked at the excerpts with confusion because I thought, this is good substantive evidence for us. So what happens is they're playing these clips, and they have an operator who's kind of isolated them haphazardly. And as John mentioned earlier in the interview, the day of Mike's deposition, Mike was here. I knew him well by then. John, I just brought him in to introduce himself. I'm talking 5 seconds and walk out. And that was the one and only time John had ever seen Mike before we started prepping for trial.
And read his deposition, but never watched it.
And Brendan, one thing that ended up being a huge theme in closing, and it exemplifies something that I said in my closing, which is, I love this case, but I hate this case. I love it because it's been the honor of a career to represent a man and a family like this, but I hate it because I've seen what has happened to this young guy over the last 10 years. And by the time we got to trial, poor Mike, he was first of all, he was sick about the whole concept of having to be there, but he had lost a bunch of weight. He looked gaunt. He lost his color. He looked frail and meek and scared. It was just, you just wanted to hug this poor damn kid. And in his deposition, which was, 7 or 8 years before that, he was still fresh off the injury. He was in his early 20s. I think he It was probably in the summer, because I remember specifically that he looked tan, he looked full-faced, and he did have kind of a comfortable way about him. So, Brendan, keep in mind that dichotomy, okay? We're sitting in the courtroom, and the video's behind, the screen's behind us. So John and I are turned with our backs to Judge Smale. And when the operator plays the clip, this is now the first time that John has spent more than 5 seconds seeing Mike Fraser and realizing how awful he has deteriorated over the last 8 years. And this, I will be lying in a deathbed somewhere and never forget this moment, because I'm looking at it thinking, geez, these guys are idiots. I can't believe they're playing this, but not really appreciating that dichotomy. At one point, a couple minutes in, John reaches over and like forcefully grabs my leg, and I lean over and he goes, Jesus, Mike, they just made you a fucking millionaire.
Just showing that.
Yep. Just showing that. Because now a jury has actually seen, not heard, not been described, not been asked to look at a picture and draw two conclusions. They have seen video evidence of what this injury has done to this man's life. And it was more powerful than anything a lawyer could ever say when describing the condition of a man.
Isn't that kind of like I put this in the context of this, grim tale, but kind of the magic of trial sometimes, like it's like in that moment, you see what you can see it, that massive distinction, the jury, it's going to hit them over the head, how profoundly this injury has impacted this kid and just withered him away. But you're doing 10 million other things, lead up to trial to put this thing together. And then that moment happens. Yeah, that's amazing.
Yeah, and so in his closing, then, so we always wondered, like, how far are they really going to go with this? John and I knew, as you would have known, that he was doing it because he wanted to be able to say, Mike's a liar, right? Because he took issue with how Mike answered questions on cross-exam in the courtroom, okay? You've seen it. Nobody is as good answering questions in a courtroom in front of a judge and jury than they are in your office. Mike, not to mention he had a brain injury, so the whole thing was really hard on him. But I didn't know or appreciate just how far Bob was going to go. He actually spent more time on Mike Fraser being a liar in his closing than he did any other substantive issue. He went so far, he said, I'm not calling him a liar, but I showed you that video because I wanted you to see something. Did you see 8 years ago Mike Fraser having any trouble answering questions? Well, geez, where was that guy in the courtroom? He seemed like he couldn't remember anything, or could he? Did you see Mike having difficulty understanding me? Well, then why was he asking me to rephrase so many questions here in trial? And you're the ones that have to evaluate credibility. And Brendan, I'm telling you, I was shocked. It was like, if there's a line for where you go on that, he was so far past it, he couldn't have seen it with binoculars. And I thought that was the biggest mistake that a lawyer could make at trial, because when I closed on that subject, what I said to the jury was, I said, folks, I guess that if I learned anything from Mr. So-and-so's closing argument, it's that there's two different kinds of people in this world. Because he watched a video of Mike Fraser and he sees a liar. I watched a video of Mike Fraser and I saw a shell of a man. What I saw was a guy who has gone from an excited, enthusiastic, healthy person managing a situation to a person who's meek, who's humble, who's scared, who has aged 50 years in the last 5. And when I look at how Mike has changed from 25 to 30, my heart breaks to think what Mike's going to look like from 30 to 40, or 40 to 50, or 50 to 60. And that's what that video shows me. Apparently not everybody sees it that way, but it was like one of those moments when your stomach just sunk, because you didn't need to hear anyone say it to know that Mike was in a really, really bad way.
Yeah, it's hard to imagine taking that line with somebody like Mike Fraser. So tell me about the verdict. So how long approximately, like what was the deliberations? Were there questions, anything like that?
Well, the first thing you have to know is when we show up for closing, they had all dressed up.
The jury.
Suits, ties, and dresses.
No kidding. Like and noticeably different than the rest of the trial.
Way different.
Wow, that's crazy. I've never experienced something like that. That's wild. So something important they were going to be part of.
Yeah. So, Mike, I don't think there was any questions.
No.
We closed. Mike closed. Really, his opening was okay, but his closing was brilliant. Really, his closing was phenomenal. And we closed midday, and they went and deliberated. And what, it was like 3 hours, Mike?
Yeah.
Yeah.
Maybe less. We got lucky. There was a room that was available on the second floor of the courthouse that was just outside the doors to the elevator. So the court staff was awesome and accommodating. They made it available to us and the Frasers. So, we went up there, and as every plaintiff's lawyer knows, those are uncomfortable moments. We certainly weren't high-fiving and eating anything. had an upset stomach the whole time, but we felt good about the case. The case went in pretty clean.
But just to show you the kind of people that the Frasers are, Mike Calder is cookie lover, in case you didn't know that. So we get up in the room, and I think we had arranged to have some sandwiches brought in and so forth. And Mary Fraser gets in her little bag because, Mike Fraser had a special diet. So they brought him meals every day. And she pulls out this big tray, and she slides across the table, and she goes, "I knew you probably wouldn't eat again, Mike. So here's some cookies for you."
Hey, and to back up, I forgot about this until now, JP, but so after the verdict, Brendan, we asked after the closing charge, we asked the Frasers to go upstairs to the room, and John and I go downstairs to the basement because we had sent Trevor on the task to find the alternates and try to talk to him. Okay. So John and I are down there, and after Trevor pranks us with the face of death, but the great news from the alternates, he whips out a book bag and hands, and there's 2 envelopes in it, one with my name on it and one to John's. These people, with no knowledge at all as to what the verdict would be, wrote us 2 of the most beautiful, sentimental, handwritten cards thanking us for believing in them, for going to bat for them, and for doing what we did in trial, and gave us each a steak.
A cowboy steak, about this big.
You should frame that letter and bronze that steak, but I'm guessing you probably ate the steak.
Well, we can't bronze the steak now, I can tell you that, but we still have the letters.
So tell us about the verdict, and just how that felt, and the family's response when that came in.
Mike and I were, the young lawyers in my office have all gotten the speech from me, regardless of what happens. You have to maintain your composure, and I can say we pretty much did. And the defense was, upset, and Mike and I felt so good that the jury understood Mike Fraser. And we all got caught up in that moment. But, we very quickly, unfortunately, we didn't have much time to celebrate because, we had to sit them down and tell them that this is the beginning of a battle, folks. The verdict is so big that even if the case had been tried completely clean, they're going to appeal. And there were some issues in the case that, in hindsight, you learn things. If Mike and I, if this case walked through the door today, we would definitely do things different than we did. But I have to tell you, I know we're not going to, get in depth about the appellate process, but, we're blessed to have a bunch of really smart lawyers working with us. The appellate process was way more difficult than the trial.
Yeah.
I mean, way more difficult. How many post-trial issues did they have the first round, Mike? 43?
It was unbelievable. I mean, that was truly a slugfest. And without getting into too much detail about it, the appellate team, which was obviously comprised of a totally different group of new lawyers that had nothing to do with the trial, concocted issues that no lawyer on earth ever would have thought of in real time, nor did they preserve them in this case. So it was a mess. But Brendan, one of the things that was kind of interesting is that the jury was able to arrive at a verdict that large that quickly. But what John and I learned from a pack of about 4 of the jurors who stuck around and talked to us afterwards was they made their initial findings on negligence, causation, and comparative negligence very, very quickly. I'm talking like within minutes. They spent the balance of the time brokering a deal on the amount of the verdict because there was at least 4 jurors who were adamant that they would only agree to a verdict that was not less than 40, but not more than $60 million. And there were other jurors that were not comfortable awarding quite that much money. And so they horse traded. And as it was, $19 million was simply the highest number that they could get a consensus on. And so they started at the total amount and then they allocated it in reverse.
Yeah, and I feel like you buried the lead. $19 million verdict, huh, guys?
And it was one of those cases, though, you have to say, and I mean, we all do this for the same reason. We were elated to get a $19 million verdict because it does take care of Mike for the rest of his life, and that's what we were in it for. But he needed a verdict just for his own well-being and to allow him to go through the rest of his life. So, Mike and I, going in, we were going to be happy with any verdict because it was a no offer case. They wouldn't save $300,000 and pay $1 million to help the kid improve his life at a time when he needed it. And they treated the Frasers like crap every step of the way. Did not allow them their dignity. In fact, were righteously indignant in their faces. And, the tears that were leaving my eyes at the verdict were for Mike Fraser, not for the amount of the verdict. I'm happy with the amount, proud of the amount. But I mean, honestly, any verdict in this case was going to make us happy because Mike and his parents needed to understand that they should not have been treated the way they were treated. And frankly, got treated through the appellate process too. They sent in another lawyer to clean things up, and we sat him down and said, you're going to lose your appellate issues. You filed your bond, so thank you. You've now taken a $1.3 million insurance policy to potentially paying us on a $20 million verdict. And by the way, its interest is running at $3,000 a day. So by the time the verdict was finally affirmed on appeal, they owed us more than the initial verdict without the comparative because we had collected so much interest over the years. But, they never, till the day they had a right to check, they never had any empathy or class expressed to the Fraser family. And it was disgusting, and they should all be embarrassed about how they treated the Frasers.
And meanwhile, talking about that journey, I mean, we're talking today because it is finally done. But when was that trial? When was the verdict?
March 2022.
So years then the family had to wait until, pretty much just recently. And yeah, we won't go into the depth of the appeals process, but, just more grinding down of this family. But, everybody hung in there and fortunately a happy ending.
Yeah, and to tell you what kind of a guy Mike is, Brendan, we've all at some point represented the person in the rear end or whiplash car accident case who calls you daily once they've signed a release and offers to meet you in the parking garage the day that the check arrives to get their, $6,500. During the entire life of not only the case, but the appeal, I got a sum total of 0 phone calls from Mike asking about the status. Not a one. And anytime I called him, because John taught me this a long time ago, and it's something I've continued to do and always will, which is I actually, to the point that I will beg people to put any feelings involving the lawsuit into a cupboard and close the door. Let us handle the legal side of things, and you please handle moving on and healing emotionally and physically. And Mike's one of the few that actually was able to do that. So I've always promised him after the verdict that I would call him anytime and every time that there was a decision ruling or a high point that he needed to know about. And you know how those phone calls would always go? They would start with just us catching up because we had that kind of relationship. And they would end with him effusively thanking me for taking time out of my day to call and give him an update on the status of his case. I mean, that's why everything we've told you about what magical people they are is just true. It was an inevitability that these people were going to be loved by a jury.
Well, I think that's a great place to wrap up, guys. Amazing story, amazing trial, obviously amazing clients. Really happy for you guys that it did end the way that it ultimately did and that we can sit here and talk about it. And you guys, provided, in addition to an amazing story, I think some really helpful ways to think about approaching some thorny issues that, you had to overcome at trial. So a lot of great takeaways here. So John Perry, Mike Calder of Perry Calder, I really appreciate you both doing this today, taking the time out. I loved it, enjoyed it. And just appreciate you guys. And if anybody wants to reach out, talk to you guys more, reach out about a case, where's the best way for people to get a hold of you guys?
www.caringlawyers.com or 412-281-4200.
Awesome. Thanks, guys. And I'm sure I'll see you around town soon. All right.
Thanks, Brendan.
Thanks, Brendan.
Thanks again to Mike Calder and John Perry for sharing the story of Mike Fraser, this powerful case, and the work that went into securing justice for an amazing family. If you enjoyed the episode, please follow or subscribe, leave a quick review, and share it with a colleague. That would mean a lot to me. We'll be back soon with more insights from the lawyers behind the verdicts and with some upcoming trial nuggets. Until next time, I'm Brendan Lupetin with Just Verdicts.
If you enjoy the show, please subscribe to the Just Verdicts podcast on your favorite platform and consider leaving a review. And if you're interested in co-counseling, local counseling, or referring a catastrophic injury case, we'd love to work with you. Call us at 412-281-4100 or visit our attorney referral page at pamedmal.com/refer. Thanks for listening.